Good afternoon. I'm John Tomasi. On behalf of the Political Theory Project, I'm delighted to welcome you to Constitution Day. Constitution Day events are being held at campuses around the country as a result of a federal mandate. That mandate requires that all universities receiving federal funds conduct activities discussing the Constitution on this date. It was, alas, an unfunded mandate. But on the upside, it gives us the opportunity to come together and talk about the Constitution. The Political Theory Project, as is its wont, seeks to empower undergraduates to create a university worthy of themselves by creating dialogues and courses worthy of Brown students. With that idea in mind, I'm going to cede the stage to Anthony Stalin, the Executive Director of the project's Janus Forum.
Good afternoon and welcome to the 13th Janus Lecture entitled The Right to Bear Arms, D.C. versus Heller Revisited. My name is Anthony Stalin and I'm the Executive Director of the Janus Forum. So what is the Janus Forum? People ask me all the time, I come to a lot of the events, but I don't really know what the overarching goal of the organization is. Well, the Janus Forum is the student arm of the Political Theory Project, which seeks to encourage and elevate the level of thought, debate, and discussion around political and social ideas at Brown. We do this through a broad range of events. We host student debates through the Janus Political Union. We host Janus Conversations, which are smaller lectures with Brown professors. We also hold open seminars at the Faculty Club, where students can come enjoy a free meal while discussing a predefined topic. And of course, then, there are the Janus Lectures. But through all these different types of events, the common thread and defining characteristic of our organization is that we seek to expose students to as many different perspectives as possible. Through our events, we promote what we like to call responsible ideology. Numerous studies suggest that people tend to converge on beliefs they find pleasing, rather than on those for which they have strong evidence. We help Brown students avoid this danger. Responsible ideology means putting in the hard work to be justified in holding one's views. Responsible ideology means confronting contrary views with an open and active mind. At the Janus Forum, we don't avoid intellectual disagreements or opposing views. On the contrary, we seek them out. We believe that it is only by challenging our own convictions and opinions and examining a broad range of perspectives that true learning can occur. And so the Janus Forum provides a place for people with diverse viewpoints to come together to discuss freely and passionately and practice responsible ideology. Of course, none of this would be possible without the support of the Political Theory Project, which is an independent research center at Brown University dedicated to the study of institutions and ideas that make societies free, prosperous, and fair. Today, we are gathered to revisit the controversial Supreme Court case of the District of Columbia versus Heller. Heller is considered a landmark case because it was the first time since 1939 the court directly addressed whether the right to own firearms, guaranteed by the Second Amendment, was an individual right or one that applied only to state militias. The case began as a suit challenging the Firearms Control Regulations Act of 1975, which prohibited D.C. residents from owning handguns. In 2008, in a 5-4 Supreme Court decision, they struck down the D.C. ordinance, deeming it unconstitutional. To present the arguments of the case and explore its implications, we are joined today by two very distinguished guests who will each speak for about 25 minutes. Unfortunately, Mr. Walter Dillinger, who represented the District of Columbia in front of the Supreme Court, had to cancel his appearance today because of a last-minute emergency. Fortunately, however, in his place, we are joined by Mr. Joseph Blocher, who was also involved in the case as he assisted the merits briefing for the District of Columbia. Mr. Blocher is an assistant professor of law at Duke University, where one of his principal areas of research has been the Second Amendment. Mr. Alan Gura represented Dick Heller in the United States Supreme Court. He is a founding member of Gura and Pazesky, and his practice focuses primarily on constitutional law. After both speakers are finished, they will have the opportunity to ask each other one question. Following that, we will open up the debate, and audience members will have the chance to ask their own questions by lining up at the 2 microphones. After the question and answer session, we invite you all to join us in the front hall for a small catered reception. And now, you've heard more than enough from me. Please join me in welcoming our first speaker, Mr. Joseph Blocher.
Thank you very much, Anthony. Thank you, John. It's a special honor to be here on Constitution Day because although Alan and I disagree about whether Heller was correctly decided, and we probably disagree about what it means going forward, we do agree very emphatically about one thing, which is that constitutional principles matter, and that they're different from regular politics, and that our goal here today is to talk about what the Second Amendment means and what it allows, and not just whether we like or dislike guns or gun control. The text of the Second Amendment reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." As Anthony just let us know, in District of Columbia v. Heller, the Supreme Court decided that this language, despite its first clause referring to a well-regulated militia, actually protects a right to own guns whether or not a person or gun bears any connection to a state militia. Now, in my remarks today, I want to focus on the relationship between politics and principle, both before and after Heller. So in the first part of my talk, I'm going to highlight how the Second Amendment came to be a part of our national discussion politically about gun control, and how originalism, as a method of constitutional interpretation, entered that discussion, and eventually entered the Supreme Court's opinion in Heller. And in the second part of my talk, I'll focus on what I think is Heller's largest shortcoming, which is that it fails to clearly identify any possible purpose of the Second Amendment. If not protecting state militias, what is the point of the Second Amendment? Is it to allow all of us to be armed individually to prevent federal tyranny? Or does it have something to do with the common law right to self-defense? These are really important questions, and the distinction between them is an important one because it leads to different places as far as what kinds of gun control might be constitutional going forward. Heller, on the other hand, approves, out of thin air, certain kinds of gun control, and then strikes down the districts, without any kind of single underlying constitutional principle to explain why. And that might be fine for politics, but it's not enough when it comes to constitutional principle. In conclusion, I'll argue not that originalism is wrong, but that it's not enough. It wasn't enough in Heller, which failed to give us any purpose behind the Second Amendment, and it's not enough going forward. Inevitably, we have to look elsewhere for tests to govern when a law is or is not constitutional, particularly in the context of the Second Amendment. And I think the best place to look is to the test which the states have almost unanimously applied under their own state constitutional equivalents of the Second Amendment. Under that test, a piece of gun control legislation is unconstitutional if it unreasonably burdens the right to bear arms. First, whether you like the result or not, and despite what Heller itself says, Heller was a massive change in American constitutional law. We wouldn't be here talking about it today if it weren't. Most importantly, it constitutionalized what had always before been a political debate, which is whether or not gun control makes sense. And since the very beginning of this country, we've had gun control in various states, cities, and even federally. We've had laws that limit who can carry guns, what kind of guns they can have, and whether those guns have to be stored in some way safely. And that was a political debate. Some cities thought it made sense, some cities and some states didn't. Those who opposed gun control won plenty of political victories, and especially in the past few decades, they've become better organized, better funded, and have delivered a clear political and sometimes constitutional message. And they've gotten it across. So in 1993, for example, Congress passed the Brady Bill, which, as some of you know, required background checks to keep people like felons from buying guns. The NRA opposed this legislation and poured money into races to punish the people who voted for it. And the majority of the 21 targeted races that the NRA spent money on, the candidates lost in 1994 as part of the Republican Revolution that swept Congress, right? NRA was effective in political terms. This is pre-Heller. And NRA has been successful even in opposing gun control, which has been politically popular. So the assault weapons ban, for example, which was allowed to expire a few years ago, supported by the majority of Americans and even by the President Bush at the time. But the NRA opposed it and it was allowed to expire. But that wasn't enough. Opponents of gun control didn't just want to win political victories, they wanted to win them constitutionally, to take gun control off the table entirely. So, and I began by saying that there's a difference between politics and the Constitution, so it's worth asking, where is the Constitution in all of this? right? It had been there all along, the Second Amendment, for 200 plus years. What did it mean? Well, in large, people understood it to be defined, in terms of purpose, by the first clause. Well-regulated militia being necessary to the security of a free state. It had to do with militias. But that wasn't going to do it for opponents of gun control, because they didn't want guns. They didn't want to possess guns just in their service in state militias. They wanted them for private purposes, for something else. So they had to alter this understood meaning of the amendment. So the first place they went was to slightly tweak it, take the militia out, and say that it has to do with the right to prevent tyranny, all of us, the general militia, not just the select militia, that all of us need to have arms, not acting through our states, but individually to prevent federal tyranny. And there's something to this, right? Because the policy, the principle behind the Constitution is to protect us from government. And it's true that the framers were scared of this concentration of power in the federal government, and especially in this new federal standing army, which they found terrifying. Now, I happen to think, and the received wisdom was for 200 years, that the way the framers prevented tyranny was by allowing the states, as sort of a countervailing check, right, checks and balances, a countervailing check on federal power. But the new rhetoric, and this came about 50 years ago, was that all of us individually were the check on federal power. Now, this didn't work out so well politically, because this view was also held by elements that were a little bit more politically extreme, right? So private militias espoused the same view. People like Timothy McVeigh. And that tainted it politically, because Timothy McVeigh, as you guys know, blew up the Oklahoma City building, the Murrah building, the federal building in 1995, arguing, among other things, that the federal government was disarming him and other citizens in order to oppress them. They needed to protect himself, right? Now, the NRA did not distance themselves from this initially. In fact, they were still referring to federal agents, including some of whom died among the 170 other people in this federal building, 20 of them children, as jackbooted thugs. This was so controversial that even the first President Bush couldn't stomach and resigned from the NRA because of it. So this anti-tyranny constitutional argument wasn't winning political points. So what do? Alter it slightly. So we've given up on the militia reading, we've given up a little bit on the individual anti-tyranny reading, and moved to a third, which is self-defense. And this, I think, became politically the most popular rationale for why the Second Amendment was in the Constitution. And let me just, as a legal point, make this clear. There is and has always been a common law right to self-defense in this country, and it has nothing to do with the Second Amendment. You could invoke it without invoking the Constitution. You had it well before Heller. You would have had it whether or not the Second Amendment had ever been ratified. It is a common law right. But this new argument attached that to the text of the Second Amendment. And it became politically popular, especially along with the sort of law and order movement, which especially became politically popular after the sort of Nixon years and is now a firm plank in both parties' platforms. So we had these two sort of constitutional political arguments floating out there. One, the sort of individual prevention of tyranny, the general militia argument, and the other one, the sort of self-defense argument. But at least until 2000 or 2001, this was all politics. And this is just worth emphasizing. Until Heller, no federal court had ever struck down a law on the basis of the Second Amendment. It had never happened. The judges and courts and lawyers on both sides of the spectrum understood the Second Amendment as having something to do with state militias, as its text implies. And here's just a few examples. Chief Justice Warren Burger, Republican appointee, conservative, said in 1991 that claims that the Second Amendment protected non-militia-related rights were, quote, the subject of one of the greatest pieces of fraud, I repeat the word fraud, on the American public by special interest groups that I have ever seen in my lifetime. Erwin Griswold, who was Nixon's Solicitor General, attacked the National Rifle Association and its friends in Congress, saying, quote, to assert that the Constitution is a barrier to reasonable gun laws in the face of the unanimous judgment of the federal courts to the contrary exceeds the limits of principled advocacy. It was out of bounds to even argue it. Finally, Robert Bork, famously conservative and originalist, said in 1989 that the Second Amendment operates to, quote, guarantee the right of states to form militias, not individuals to bear arms, and went on to say, quote, the National Rifle Association is always arguing that the Second Amendment determines the right to bear arms, but I think it really is people's right to bear arms in a militia. The NRA thinks that it protects their right to have Teflon-coated bullets, but that's not the original understanding. Close quote. That's not the original understanding. Now, did this mean that guns were illegal everywhere? No. It just meant that it was up to legislatures to decide. Some legislatures decided to regulate them, especially those in urban areas like the District of Columbia, which had exceptional problems with gun violence, but most didn't, because, as we discussed earlier, the anti-gun control movement was politically powerful enough to stop most gun control. Did this mean that self-defense was illegal? No, because this common law right to self-defense has always existed as a general exception to generally applicable laws. If somebody charges you with murder because you killed somebody and you say, no, 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 I had to, he was attacking me, and you can prove that, you have that common law right to self-defense. You don't have to cite the Second Amendment for it. That had always been the case. But this wasn't enough for opponents of gun control. They wanted more. They wanted to take these things off the table entirely because they felt they were constitutional rights, not political ones. But there was a trick. This was hard, politically, because the same people, many of them self-styled conservatives, who'd been attacking gun control for so long, had also been attacking the federal courts as activists because they strike down popularly enacted legislation. This unelected, unaccountable federal judiciary was striking down laws. They're activists. So how can we now turn to those courts and tell them to change this 200 years of understanding about the Second Amendment and strike down popularly enacted gun control? This is a conundrum. And this is where originalism comes in. Because originalism purports to restore the Constitution rather than interpreting it, right? The judge doesn't do anything. They just deliver what was the understanding at the time of the framing. And politically and rhetorically, that's a useful distinction, right? Because it sounds great. But jurisprudentially, it's a distinction that doesn't mean anything at all. Because every judge, and I have to emphasize this too, every judge and every justice thinks that the Constitution is binding. The Constitution says so, Article 6 of it. That's never the question. And every justice and every judge thinks that the original intent and the original understanding is something special. That's why both the majority and the dissent in Heller are arguing in originalist terms. So it's never a question of whether you think the Constitution matters or whether you think originalism matters. The question always is, how do you determine what these original understandings were and translate them into modern doctrine to govern problems that the framers didn't have to deal with? Uzis and machine guns and flamethrowers and things like that that they didn't ever have to imagine. The promise of originalism, at least politically, is that it gives us some kind of neutral, framer-given principle that justifies having unelected judges tell democratically accounted majorities, democratically elected officials that they can't do what they want to do. So then I think the important question to ask is, what principle does Heller give us? What principle does Heller deliver that tells the District of Columbia and its elected officials that they can't do what they want to do to protect themselves from gun violence? And shockingly, I think, we know very little about what the point of the Second Amendment is, even after Heller. And Heller's purported originalism doesn't help deliver that any more than the political rhetoric that preceded it. First, to back up and talk about the decision a little bit more. The court struck down the District of Columbia's handgun registration program, which effectively banned handguns. But it also approved 5 other kinds of gun control. It approved, out of thin air, bans on possession by felons, bans on possession by the mentally ill, bans on dangerous and unusual weapons, bans on possession of weapons in government buildings, and bans on possession of weapons with no military utility. Now, whether or not we like those 5, and I think most people agree, yeah, that makes sense. I don't want felons to have guns. We started off talking today about constitutional principle. In order to have these 5 be okay and this one not, there needs to be a reason. And it's not just that we like these and we don't like this one. There needs to be a constitutional principle at work here. And that's what I think Heller fails to deliver. And why is that a problem? Because these 5 and this one are not the whole universe of gun control. What about children? What about drug users? What about illegal aliens? These are all groups which are denied the right to own guns under current federal law. And Heller doesn't tell us anything about them. So how is a lower court judge, and they're all right now trying to work out these Second Amendment problems, Allen's litigating a lot of these cases, they're trying to figure out, are illegal aliens like these 5, which are okay, or are they like the handgun ban, which is not? In order to do that, in order to answer that question, they need to know what the point of the Second Amendment is. And as I see it, there are 3 possible purposes for what the Second Amendment might mean. The first, which I'm not going to talk a lot about because the court clearly rejects it in Heller, is that the Second Amendment is there, as the text suggests, to protect state militias from disarmament by the federal government. Heller flatly rejects that. I'm not going to re-argue it. It's off the table. The second is the one that we talked about just a minute ago, the sort of anti-tyranny view, right? That the amendment is there to protect us from the federal government, not through state militias, but by allowing all of us, the so-called general militia, to be armed. So let's see if we can square that principle with these 5 things that the court has told us are okay. So the court starts off by saying that dangerous and unusual weapons can be banned. Can we square that with an amendment whose purpose is to prevent federal tyranny? What kind of guns would you need to overthrow a tyrannical federal government? Grenade launchers and flamethrowers and rocket launchers and bombs and tanks and missiles. It doesn't make sense as a matter of principle. The court is carving out exactly the kinds of weapons that you would need in order to effectuate the right. Now, we might like it as a matter of politics. I happen to. Don't get me wrong. I'm not arguing that I like missiles to be covered by the Second Amendment. But if the principle is the prevention of federal tyranny, it would certainly seem that that's the core of the right. That's number 1 on our list of 5. Another one of those was sensitive places, like government buildings. Where do you need to take your flamethrower to effectuate your... Take it to Congress, right? This is the core of the Second Amendment right. And again, it sounds ridiculous, and I'm not arguing for it. I mean, don't arrest me. I see people back. The point is just that if this is the principle that we're enunciating, we have to be honest about it and where it takes us. And sometimes constitutional principles lead to bad places. If they lead to places that are this bad, maybe we need to recheck the principle. And third, just as a matter of sort of general structure, I said, and it's true, that the Constitution is there to protect us against the federal government. But it's worth asking whether the framers at the time of the founding really wanted to constitutionalize this right to individual armed rebellion, as opposed to having states serve as the bulwark against federal authority. Right? The framers had just spent the past few years fighting against domestic insurrection, some of which we maybe learned in history class, but maybe didn't. Shays' Rebellion, right? These sort of domestic insurrections. The Constitution makes treason a crime. It's a constitutional crime. And in fact, the militia clauses of the Constitution allow Congress to call out the militias specifically for the purpose of putting down domestic insurrections. So you may have a right to overthrow a tyrannical government, but does it make sense that you have to cite the Constitution to do it? You're going to go to a federal court and explain to the federal judge why your possession of this flamethrower is important to overthrow the tyrannical government of which the federal court is a part? Just as a matter of implementation, it sounds difficult, right? And I think the reason for this is that once you take out the militias, which is the mechanism that the framers chose, and I think, to prevent federal tyranny, you get to complicated results which nobody wants to deal with, and the Supreme Court didn't want to deal with. So they turned, as people had politically in the decades before, to the sort of self-defense rationale and said that the core of the Second Amendment, which says nothing about self-defense, again, it's well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. There's nothing that says anything, specifically at least, about self-defense. The court nevertheless says that that is the core of the amendment's protection. Now again, I like self-defense. I think it's an important thing, and we have a common law right to self-defense. But does it make sense to graft that on to the Second Amendment, which talks about militias and arms? Consider this. Does that mean that we now have a constitutional right to defend ourselves with guns, but not a constitutional right to defend ourselves with fists? It seems bizarre. Why would the framers do that? It creates weird incentives too, right? You have more of a right to shoot an intruder than you do to stab him or to punch him. And consider, let's go back to our list of people who the Supreme Court says have no Second Amendment rights. Can we square that with a self-defense principle? The court says that felons have no Second Amendment rights. Felons have self-defense rights. If you attack somebody who's been convicted of a felony, they can defend themselves and claim the common law right. Also on that list was the mentally ill. The mentally ill have a common law right to self-defense. The court also said that the Second Amendment doesn't extend to sensitive places like government buildings. You can defend yourself in a government building as well. The carve-outs don't square with the principle. Again, I like the results for a lot of these. I think a lot of people do. They make sense. But they're out of thin air. They're the kinds of things we would expect from politics, but we can't deal with if they're supposed to be justified according to constitutional principle. So we've seen that, and fifth on that list, so just so we can knock out all 5, the fifth on that list was that weapons with no military utility, potentially not covered by the Second Amendment. Why do we care about military utility if the point of the amendment is self-defense? It's totally irrelevant. The principle doesn't make sense. Now again, like the result politically, but what's the principle at work? So we've already seen that all 5 of these gun control measures which the court has supposedly justified are in fact inconsistent with these 2 new purposes of the Second Amendment. And what about all those hard questions which the court doesn't answer or doesn't even ask? If the binding constitutional principle here is that people who have the right to self-defense also have Second Amendment rights, then there's a lot more gun laws at risk. Think about children. 13 and 14-year-old people have a common law right to self-defense. They can fight back if you attack them. But currently, at least, they're not allowed to buy handguns, shotguns, or rifles under federal law. Consider illegal aliens. Same issue. Drug users. Same issue. Same is also true for gun laws which restrict possession in certain places, like schools. You have a common law right to self-defense while you're in a school. So does that mean that all laws which prevent the possession of guns or use of guns in schools are unconstitutional under the Second Amendment? Now, Alan may suggest, and there's an argument to be made that we'll get better answers by holding aside this kind of purposivist analysis and just looking to what happened at the time of the framing, right? Don't even try to figure out what they thought, what they intended, or what they understood. Just look to what they did. The problem with that is that originalism just doesn't give us all the answers. Sometimes it gives us unacceptable answers, and sometimes it gives us no answers whatsoever, right? Who got to serve in the general militia, or the select militia, or even the general militia at the time of the framing? Women? No. It was white men, right? We definitely don't want that to be to whom the Second Amendment extends, and maybe it's changed since then and more people have come within its scope, but that's living constitutionalism. It's not originalism anymore. And how would an originalist even begin, how does originalism even begin to answer questions like, how do we deal with rocket launchers? We could say that they're the lineal descendant of some kind of weapon that existed at the time of the framing, but which? Is it a lineal descendant of a musket? Because back then, muskets were, that was top of the line, right? That was a handheld weapon with massive destructive power at the time. So maybe that was the then equivalent of a rocket launcher. Or maybe rocket launchers are descendants of cannons because they can do so much work. And maybe cannons were regulatable at the time of the framing, but muskets weren't. How can we figure any of this out? The point is that you need to know what the purpose of the amendment is, and Heller doesn't tell us. Now let me be clear. I don't fault Heller for failing to answer in one fell swoop all the possible questions about gun control. But constitutionalizing this political debate makes principles matter. And Heller's supposed originalism doesn't simply fail to provide answers to these questions, it prohibits us from answering them through the democratic process. It takes them off the table. So what should we do? How are courts supposed to evaluate whether a particular piece of gun control is constitutional? And let me start by reiterating some more things that Alan and I definitely agree about. First, if a law violates a constitutional right, it's unconstitutional and has to be struck down. That is the basis of judicial review. It's the basis of our constitutional system. The question always is whether a law violates a constitutional right and whether it is unconstitutional. Not every regulation of a constitutional right is a violation of that right. Your First Amendment rights, for example, can be regulated in all kinds of ways, according to the time, place, and manner of where you're speaking. Even according to the content of your speech, you might lose all First Amendment protection, right? Obscenity, fighting words, yelling fire in this theater, right? Those are not covered by the First Amendment at all, even though they're speech. There are parts of the Bill of Rights which essentially have no applicability today. Consider the Second Amendment's other neighbor, the Third Amendment. Does anybody know what the Third Amendment is? Prohibits the government from quartering troops in your home, right? This is a big concern at the time of the framers, but it served its purpose. The government doesn't do it, and it doesn't get invoked anymore, right? So it's not enough to just say, well, the Second Amendment's in the Bill of Rights, therefore anything that violates, anything that regulates guns is unconstitutional. You need to know more than that. Now, it is clear that Heller creates some kind of new twist, at least, on a constitutional right. It says there's a right to possess firearms even without having to justify it as related to present, future, or even potential militia service. The question remains, what kind of restrictions violate that right? The best standard, I think, that we could use for the Second Amendment going forward is the same standard that the states have almost unanimously adopted under their own versions of the Second Amendment. Under that test, a piece of gun control legislation would be unconstitutional if it unreasonably interferes with the right to bear arms. Otherwise, we defer to the determination of the politically elected branches. Now, this approach would not deny protection to guns, but it wouldn't give them any more protection than under other rights in the Bill of Rights get. We apply this kind of rationality, reasonableness review, to all kinds of important constitutional rights, to burdens on all kinds of important constitutional rights. Lots of kinds of free speech get this kind of intermediate reasonableness scrutiny. Laws that discriminate against people on the basis of their sexuality get this kind of reasoning. Economic regulations get this kind of reasoning. And it's just impossible for me to imagine that the framers intended to allow dangerous speech to be regulated, but not dangerous guns. Now, there is a degree to which originalism precludes deference, right? And the argument clearly can be made that if there's an originalist answer, then you don't even need to look to what the political branches are doing because the framers have told us what to do. And that's true where originalism gives us answers. But what I've tried to do here is show that originalism can't, and doesn't have to give us all the answers. It just has to give us some kind of principle to work with. I think it's better to count on originalism to provide us with those principles. But instead of doing that, Heller tried to look to originalism to provide all the answers, and then just carved out the results it didn't like. Felons, the mentally ill, dangerous and unusual weapons, and so on. That may be political, but it's not principled. Originalism is a starting point and not an end, which is why I think that it is not enough to be an originalist. The Constitution itself demands more. And finally, I just want to come back to the fact that I opened my remarks by recounting the incredible successes of the anti-gun control movement in both the political and constitutional arena. And whether or not you think that's a positive development, I hope that everyone here leaves inspired by the power of social movements and of ideas and of the responsibility that comes with invoking and employing the Constitution. Thank you.
Thank you, Mr. Blocher. Please join me now in welcoming Mr. Alan Gura.
Thank you so much for having me here. Just by a quick show of hands, how many people here in the audience have read the Heller decision? Okay, a few people. The justices and their clerks put far more than 25 minutes of their time to expound on their positions. And the briefing that was submitted to the court and the work of the court itself was itself the culmination of many, many, many lifetimes of research and thought. I think we can all agree, all of us who follow this debate closely, that the opinions of all the justices, the majority opinion as well as the two dissenting opinions, are all quite excellent, very accessible. You don't have to be a lawyer to read it, and I would encourage all of you to go out there and actually read the Heller opinion and see what it says. I don't believe that neither I nor Professor Blocher can do justice to the various arguments made in that opinion, but Professor Blocher did try, and so will I. The nice thing about the Heller opinion, first of all, regardless of what you feel about guns or gun control, is that all of us who work in the law within an adversary system are pro-work. And Heller definitely gives us a lot of work to do. It does not answer all the questions that are out there, and that's fine. Our system is not designed to allow one Supreme Court decision to answer all the questions. We don't have one First Amendment case that tells us for all time what free speech is, what is speech, when is it protected, when is it not protected. There is not one case that for all time tells us what's a search, what's a seizure, when are they reasonable. It would make for a very short order of law and order, a very short season of law and order if there was just one case everybody could cite to and all the questions would be answered. And so there's not going to be ever a Second Amendment case that answers all the questions. However, I think where I disagree greatly with Professor Blocher is that I do think Heller gives us an awful lot of guidance, and it does answer a lot of questions. At least it gives us a roadmap by which we can evaluate some of these questions and have fairly educated guesses or at least coherent arguments on both sides of the issue as to how these future cases should be decided. I'm going to go over that. But before I do that, I want to talk a little bit about what Heller decided and what it did not decide, because I think that's important, especially in light of the comments you've just heard. The ultimate benefit of Heller is that it determined that the Second Amendment right of the people to keep and bear arms is a normal part of the Bill of Rights. This is a right of the people. After all, those are the words used in the Second Amendment, just like the words of the First Amendment speak to a right of the people, just like the words of the Fourth Amendment speak to a right of the people. It's the people that have the right, not a militia, not the states. The people have the right. There is this militia language that opens the that opens up the amendment. It is one of three preambles in the Constitution that inform the operative text that follows. The others, of course, are the general preamble, we the people, the United States, all that flowery language. And of course, for those of you who follow these things, Congress's power to create a system of copyrights and patents exists only because Congress has the need to promote the progress of science and the useful arts. But never has there been any case that accepted, in fact, the cases universally reject the idea that such language controls the kind of laws that Congress can pass respecting copyright and patent, or the kind of copyrights and patents that you may all obtain for your various discoveries and inventions. And likewise, the militia clause of the Second Amendment is read the same way. It provides a reason why we've codified the right, and I'm going to get into that shortly. However, the reasoning does not limit the result. That is a very basic operating tool that lawyers and courts have used since the beginning of time to interpret statutory and constitutional text. And the Second Amendment is no different than that. Yes, there is a militia purpose. It's not the only purpose. It's not the exclusive purpose. But it does not define or limit the right. That's not the way that we look at legal language. And let's look at what that purpose tells us. What exactly is the militia? We hear a lot of talk about this word, and I think it means something very different to a 21st century audience here who might think of the militia as perhaps the late Patrick Swayze in Red Dawn, or a bunch of guys drinking beer out in the woods complaining about the government. But that's not actually what the framers thought of the militia. To the framers, the militia simply meant that part of the general public that was capable of bearing arms for the defense of the community. Remember, this is a time when standing armies were frowned upon. There was no organized police force. There was no dialing 911. The militia was just you and I. It was the people who were expected to have arms in their homes because arms were a normal part of life. And when called upon to do so, the militia would gather together and defend the community in time of need. How can the militia be effective? Well, one way you preserve the effectiveness of the people to act as militia is by guaranteeing them the right to own guns, because, of course, if you don't have guns, you're not going to do a very good job of acting as militia. However, the right is one that belongs to the people, and on this I think the history is quite clear. Here's what George Mason said during the constitutional debates. Quote, "Who are the militia? They consist now of the whole people." Okay? Fairly simple answer. Akil Amar teaches down the street from here, a very noted constitutional scholar today, also has written the militia is identical to the people. Not much dispute about that. Let's go back to U.S. versus Miller, the famed 1939 Supreme Court case that the other side complains was abandoned in Heller. Here's what Miller says about the militia. This is the Supreme Court 60 some odd years ago. "The militia are not troops or standing armies, but civilians primarily, all males physically capable of acting in concert for the common defense." And if we look to see what the framers of the Constitution said about the militia, here's what James Madison, author of the Second Amendment, wrote about it in the Federalist Papers, speaking of the militia amounting at the time to near 500,000 citizens with arms in their hands, who he said could resist an oppressive standing army. And this militia reflected, quote, "the advantage of being armed, which the American people possess over the people of almost every other nation, in contrast to, quote, governments that are afraid to trust the people with arms." The Boston Evening Post in 1768, as revolutionary fervor was sweeping the land, spoke of the total number of the militia in the large province of New England being upwards of 150,000 men, who all have and can use arms. And so clearly we see that the militia simply referred to a social construct. It was not as some sort of specific group that existed out there. And why was it that people had guns in early America? Well, because the English law at the time, by that time, had settled and determined that people have a right to arms. Malik versus Eastley, a case from 1744, well before the Second Amendment, one that we cite to quite often, and the Supreme Court relied upon it as well, stated that English law had settled and determined that a man may keep a gun for the defense of his house and family. Again, jolly old England in the 1700s, and of course that's not a surprise because England had in its Declaration of Rights 1689 no militia system, but the right of people to have arms. And when James Madison took the floor to introduce the Bill of Rights before the first Congress, we can look at his notes for the speech that he gave that day, and he references the English Bill of Rights, and specifically with respect to the right to arms, the problem, the limitation that the English Bill of Rights had, the defect that he was improving upon, was that the English right was limited to Protestants, and of course, there is no such limitation in the American Constitution. It's a right that belongs to all the people. I could go on and on and on and on, but the fact is that as Heller recounted, and as there are many books and articles out there explain in far greater detail, the right to arms was understood to be a popular right. It was understood to be one that was for the purpose of self-defense, both as an immediate matter against private violence as well as against public violence in the event that the government were to become tyrannical. There's absolutely zero support, no historical support whatsoever for the collective rights theory of the Second Amendment. Not one single person during the framing era stood up and said, you know, we're ratifying the Second Amendment because we believe the states have the authority, the military authority to check the federal government. There were people who wanted that result. There were separate amendments proposed along those lines, amendments that were designed to give back control over local militias to state authority over from the federal government, and those amendments were all defeated. Interestingly, sometimes they were proposed right alongside the Second Amendment. You would have demands for rights that would spell out Second Amendment-like language, demanding a right to arms, right alongside a right of the states to have some sort of military autonomy from the federal government, and we all know that the first one got ratified and the second one got rejected. I'm a little surprised to hear that the Second Amendment is supposed to allow the states to check federal power. We tried that in the 1860s, and I think the result was correct. Thankfully, at Appomattox Courthouse, that theory ended. However, it should be noted that at least one judge in the era did view, had this esoteric view that the Second Amendment actually allowed for some sort of resistance to the federal government. In Pennsylvania, the Supreme Court for a time enjoined the Union draft during the Civil War in the early 1860s. Eventually, the court reversed itself. However, in a concurring opinion supporting that outcome, there was a theory thrown out that the Second Amendment gives the states control over their populations for military reasons, and this is why Abraham Lincoln could not draft soldiers out of Pennsylvania to fight the Civil War. In any event, we're well beyond that. We do now have a meaningful individual Second Amendment right. That's what the original text means. That's what the framers intended, and that's what we have. There are no guarantees that it will be faithfully followed in future years. Of course, courts change. Sometimes courts accept difficult and unpleasant theories that we may not like as litigators. But if Heller is to be taken at face value, what does that mean for the future? How do we see this going forward? Well, first of all, like all rights, there is an absolute core to the Second Amendment, just like there's an absolute core to the First Amendment or the Fourth Amendment or the Eighth Amendment. For example, you cannot ban all speech. You cannot ban all religion. You cannot ban all arms. In Washington, D.C., one of the laws that we challenged was effectively a functional firearms ban. D.C. said, well, you can have rifles and shotguns. They simply may never be operable. The moment that you render your rifle operable, the minute you have it assembled and loaded, you're committing a violation. So if a bad guy breaks into your house in the middle of the night, you happen to have a shotgun, the only thing you can do is whack them over the head with it or throw it at them. But don't you dare load that shotgun, you'll be committing a crime. We argued if you have a right to arms, you have a right to arms that actually work and that you can use, at least in self-defense. And the court agreed with that and struck down the functional firearms ban. That was a decision that called for the court to interpret the meaning of the Second Amendment, not really to construe it. And there is a big difference. However, future cases, of course, are going to be in what we call the construction zone, when the history runs out and there are no framing error practices or no sort of commonsensical obvious things, and you do have to engage in some construction to see what the result would be. Of course, there have always been some regulations on the right to arms. There always will be some regulations, just like there have always been regulations on speech and always will be. However, there is going to be some role now for the individual right to balance the scales in the interest of liberty. Now, beyond the core, once you get into the construction zone, what standard do you apply? Those of you who know something about the law, unfortunately, know that the court has these different standards of review that they apply to different individual rights. Some rights are given a very low standard of review where the government pretty much gets to do whatever it wants. The court will make up an excuse for the government regulation if it can to uphold it. Other rights are taken more seriously. Well, the Heller opinion, while it was not called upon to tell us exactly what the standard of review is, did give us a pretty good clue. If you look at footnote 26, it said pretty much the right to arms is enumerated. It's spelled out in the text. And what do we know about that? In the late 1930s, and perhaps the most famous footnote of all time in constitutional law, footnote 4 of Killing Products, the court announced a paradigm that said if it's spelled out in the text, it gets a lot of protection. Things that are not spelled out in the text, the government will have more deference. I personally believe that we can and should then see the Second Amendment take its rightful place alongside the First Amendment and the other amendments, and therefore gain the protection of strict scrutiny. What that means is that the government will have the burden of showing that the regulation it proposes to impose that touches upon the right to arms is one that actually vindicates a substantial state interest in a way that is narrowly tailored to respect the individual right at issue, that there are no less restrictive alternatives on the individual right, that there's truly a compelling interest and no intrusion into traditional practice. I think a lot of gun control laws probably passed that test, and the ban on felons is probably one of them. I do agree with critics of the Heller opinion, as Professor Blocher noted, that the dicta suggesting possible exceptions could have been better written. There is actually a reason offered by the majority opinion for those presumptively lawful restrictions, and that is they say that there are historical practices that substantiate these kinds of restrictions. I think if you look to the historical practices, you'll see that not all of them actually are of ancient vintage. Some of them are actually quite new. In particular, the felon ban is actually kind of a modern law. Historically, we've not had very many restrictions on the rights of felons because historically there were very few felonies, and most of them ended at the gallows. If you were a felon, you didn't really worry about your right to vote or your right to guns. You were probably going to be executed. Felonies were murder, rape, things like that. Now we've over-criminalized, I think, to a large extent, a lot of activity, and so we have many, many, many felons, but there's not an historical practice for this. Nonetheless, I do believe that there is a compelling interest that the state has to keep firearms away from dangerous people, and if you've been convicted of a crime that shows that you're a dangerous person, then yeah, we should be able to take the guns away from you. I don't think that's a problem. If you want to keep your guns, don't commit any felonies. I don't see this as being very controversial. The controversy arises, I think, where it normally does in this area, not with the consequences for felony conduct, but with the definition of felony conduct. We have far too many laws these days. There's a wonderful law review article that addresses the felon ban, very interesting historical piece of research. And the title of this article, of course, is "Should Martha Stewart Have a Gun?" Martha, I don't know, I'm not afraid of, if Martha wants to have a gun, I'm probably fine with that. It's not something that keeps me up at night. And in fact, of course, we have had some experience with strict scrutiny in this country. The Fifth Circuit Court of Appeals, which found for the individual right a long time ago, has been using a form of strict scrutiny since about 2001. Really hasn't had too many problems. The one thing that was clearly rejected in Heller is the so-called rational basis test, the idea that as long as the government throws some numbers at you, everything is fine. No, that's not the way we deal with fundamental enumerated rights, and it's not the way the Second Amendment is going to be dealt with. There is 100% uniform agreement in this area by all people, I'm sure Professor Blocher would agree, that guns, whatever else they are a leading cause of statistics. However, if you read our brief, at least, in the Supreme Court, we shied away from that. I personally believe that the criminological data is overwhelming, that there's a net benefit, a tremendous net benefit to society from having law-abiding people armed. However, the question is one of law, not one of policy, and so we address this as, what does the Constitution actually mean? I'm sure everybody here can find at least one part of the Constitution that they believe reflects poor public policy. Maybe it's not the Second Amendment. Maybe some of you don't like paying income taxes and think that's a mistake. Maybe some people have different views about the protection of speech, who gets to declare war, all these other things. The fact of the matter is that we have a way of amending the Constitution, and we don't amend the Constitution by deciding amongst ourselves that we're going to ignore parts of it that are simply no longer convenient. Once we do that, we really have abandoned the Constitution entirely, and we're in a form of some kind of an anarchistic system where there is no fixed law, and the law is whatever we decide it means, whatever judges decide it means, or even worse, whatever legislators decide it means if the judges are going to be differential and not do their job to stand up and enforce the Constitution. So I think it's very important that we agree, whatever our position about the meaning of the Constitution, that it does have a fixed meaning. Once you give that up, you really have no Constitution left, and then it's just a policy debate. So we do not argue this issue is one of social science in any event. However, the social science may be of some use once you get into a balancing inquiry under the strict scrutiny standard. The one test that Heller gave us absolutely, because the handgun ban was at issue, was what kind of arms are included. Obviously, there's going to be a limiting principle here. The first one is, what's an arm? Is this computer an arm? Probably not. You can use it as a weapon. I wish you wouldn't. I have a lot of data on it. But it's not something that traditionally people look at as an arm. And here the court answered the question with reference to Old English law. There is, the English language has been around for a while. An arm is anything that a person can take in their hands to defend themselves or to use in an offensive manner. And so that leaves out the cruise missiles and the aircraft carriers and the other exotic weaponry. That still leaves you a large universe of things. We've heard things about grenade launchers and flamethrowers. Sadly, for some people, I believe those are out too, because Heller adopted what we've come to call the common use test. That is, the Second Amendment embodies the understanding that arms will be used commonly by people for everyday lawful purposes. And so what we protect are those arms which are or would be in common use by law-abiding people for lawful purposes. A handgun, clearly the preeminent self-defense weapon in America, very common also for the shooting sports. You cannot ban handguns. Flamethrowers, raise your hands if you have one at home. Okay. One person has a flamethrower, obviously not in common use. I think that's sort of a commonsensical position. We're going to be arguing about this, obviously, for a long time. You see generally two different kinds of gun bans in America these days. You see some laws that require guns to have certain features. Handgun rostering laws work this way. Some laws ban guns if they contain certain features. So-called assault weapons ban work this way. I think all those laws now are basically in play now. I think if you want to ban some kind of a handgun or some kind of so-called assault weapon, you have to do it by reference to whether it's dangerous and unusual and whether it's something that people would have in common use for traditional lawful purposes. And that's really the text from which we proceed. And I think it's one that we're going to see be quite useful. Now, beyond that, Heller also answered some other interesting questions. Do you have the right to carry a gun? Not really at issue in Washington, D.C.'s case that we had, because at that point we were only challenging the right to possess a gun at home. Well, the Constitution does say you have the right to keep and bear arms. Those are two separate concepts, and we have a lot of parts of the Bill of Rights that have that sort of syntax. For example, the Eighth Amendment prevents the government from imposing cruel and unusual punishment. Those are two different concepts. The government doesn't get to torture you if it tortures everybody who gets a parking ticket. At the same time, the Sixth Amendment guarantees you a trial. It guarantees you a right to a speedy and public trial, not a trial that's speedy and secretive or slow in public. Those are two separate interests. And likewise, keep and bear are two separate interests. It's interesting that this question was actually decided what the meaning of bear arms is, because the other side had this argument that they offered that bear arms had a sort of a specific military idiomatic meaning to bear arms as to soldier. The Supreme Court looked at the history, saw that bear arms actually was used in a civilian context many, many, many times. Bearing meant to carry. In fact, Justice Ginsburg in 1998 offered an opinion that defined bearing arms as used in the Second Amendment as meaning to carry. And so you see different references in Heller as the Second Amendment guaranteeing the right to keep and carry a weapon. So carrying actually is protected. Does that mean that it's above and beyond regulation? No, it doesn't. But it does mean that in those few states, those holdout states, where it's generally difficult to obtain a license to carry a gun, you're going to see litigation, and you're going to see litigation that I hope is going to be successful, especially because I'm handling some of it. Will it have a major impact on lives of most Americans? Oh, probably not, because in most states you do have constitutional regimes for issuing handgun carry licenses. It's not unusual. It might be unusual in 5 or 6 states, but really in most of the country it's quite common and not a problem. And finally, I should say that the next big question, of course, under the Second Amendment is, does the Second Amendment apply to states and local governments? In Heller, we decided it applied to a unit of the federal government, namely Washington, D.C. Is it incorporated under the 14th Amendment? I could probably spend an hour talking about that. However, I'm pretty sure that Professor Blocher, I know, in fact, agrees with me on this. In fact, most anti-gun people agree with me on this. Not all of them. Some of them are still holding out hope. But if you accept Heller, if you accept what Heller tells you about the meaning of the Second Amendment, then it is inexorable. What follows from that is that it's going to be a right that applies to the states and local governments. I have a case, one of the cases coming out of Chicago that the Supreme Court is looking at this term. Hopefully they'll take it. I think it's just a matter of time that you will see the Second Amendment applied to the states and local governments. I want to spend the remaining 3.5 minutes or so that I've got here. I'm getting a frown. Okay, yes, okay. In any system of law, whether you have an Athenian democracy or a Saddam Hussein-style dictatorship or something in between, definitely in our country, any system of law, any system of government that's not an anarchy, has to have, for lack of a better word, what the former president told us, a decider, right? And the decider in our country is not the president. The decider, at least as to matters of constitutional law, is the Supreme Court. The Supreme Court tells you what the Constitution means, and that is binding. There really is no alternative to that that would leave you with any measure of liberty or any sort of constraint on the government. There are many people on the legal right who are more authoritarian in nature, who have a problem with this. And I think this is largely a reaction to Roe versus Wade. The famous abortion opinion that came out a long time ago upset a lot of people who were not merely content to be upset with the result in Roe, the idea that there was a right to have an abortion discovered in the Due Process Clause of the 14th Amendment. Rather, these people saw Roe as problematic because in Roe you had the court actually exercising the power of judicial review and striking down laws. And so you saw a current in American political thought get re-energized along the lines of, we must be opposed to judicial activism. Now, if activism means making stuff up, I suppose that everyone in this room could agree that that's a bad thing. Courts should not make stuff up that's not in the Constitution. Whether you think abortion is made up or there is an entirely different question. Everyone could agree that you shouldn't invent things out of thin air. However, if activism means the court taking its job seriously, engaging the Constitution and guaranteeing our rights, then I think we need to have a lot more activism out there. I wrote a law review article recently, just published by the UCLA Law Review, that takes issue with some of these criticisms, primarily the criticism offered by Judge Wilkinson of the Fourth Circuit that Heller is just like Roe. No, it's not. First of all, there is a Second Amendment. It means something, and if the history takes you to the conclusion that there is an individual right, then the courts have no option but to enforce it and to take it seriously. If politicians do not take their job seriously to determine the Constitution's meaning, the Constitution will disappear, and I think we'll all be poorer for it. We can have a debate about what it means, but I don't think that we should be debating the fact that our judges are in fact empowered to and should take it seriously and step in and use their power, I hope, much more frequently to strike down laws, whatever laws they might be, that violate some part of the Constitution. Thank you very much.
Great, thank you. Now we are moving to the Q&A part of the event. We'll start with the speakers asking each other one question, and then you guys can all line up at the two mics to ask your own questions. I'd just like to say that as there are many people who will want to ask questions and we only have a limited amount of time, we ask that you keep your questions as concise as possible and certainly no longer than 35 seconds. And on the same note, we'll ask both our speakers to keep their answers succinct as well. One final note. Each lecture, we give out the Hardball Award to the person who asks the most challenging, interesting, and thoughtful question. The winner of the most recent lecture, the winner of the Hardball from the most recent lecture was Matt Axe. And if you wish to be considered for the award, please state your full name before you ask your question. However, If you ask a particularly easy or non-rigorous question to our speakers, beware of the softball award which awaits you. And now, Mr. Blocher, if you'd like to start with your question.
Sure, yeah, I actually want to, whoa, I was a little more heavily armed than I realized there. I actually wanted to come back to something that Mr. Gura mentioned during his speech, which is the so-called functional firearms ban, which I glossed over in my speech. This was also struck down by the court in Heller, and I have a question about it. But first, just say something about what it was. This was a law that required a gun when not in use, to be kept locked or disassembled. And there was a dispute about how this should be read. The district said it should be read to have an implied self-defense exception. If somebody's in your house, we're not going to actually prosecute somebody for unlocking their gun and using it. And in fact, this law had never been applied. And the district said, don't create a problem when there isn't one. Now, as Alan pointed out, the court said, well, there's no self-defense exception in it, and therefore it's unconstitutional. So my question was, do you think if there had actually been a self-defense exception in the law, do you think that the trigger lock ban would have been constitutional?
Well, it's always hard to speculate about what if the law were written somewhat differently. I think that there were other problems with that law. You needed to have more there. Actually, it's a great question. First of all, the reason why there was no self-defense exception read into that law is because there were other exceptions there. There was an exception for having an operable firearm in a place of business, just not inside your home. And also you can have an operable firearm if you're engaged in recreational shooting, and it was never been determined that self-defense in your home is recreational. The other problem...
I agree.
The other problem was that in a 1978 case, DC took the position, they litigated quite strenuously, that it was okay to ban self-defense in the home and allow it in a business. There was an equal protection claim. Somebody said, this is irrational. Why can I defend a business but not my house? And the district said, they brought up all this gobbledygoo of social science data saying that, it's okay to have a gun at your business but not at your house, and they prevailed on that. And so the court said, listen, there's no exception here. There are other exceptions. You defend the distinction. It's quite clearly the way it's written. I think that you can have constitutional self-storage laws, but they have to allow for people to access guns, and that's going to be a different situation for different people. Interestingly enough, I just filed an amicus brief in the Supreme Judicial Court of Massachusetts in a case that's going to be heard in probably November on this topic. Massachusetts is considering the constitutionality of its safe storage law, and basically I think it's okay to require people to have guns locked up and inaccessible when they're out of the home. However, once, if people are home, you should generally allow them to access operable firearms in case an emergency arises. For most people, it's not a problem. There are quick release safes where you can have a handgun and punch in a key code and get your gun. If there's nobody home, okay, I could see where the state would say, your interest in immediate self-defense is zero because you're not there. And what if somebody steals the gun, put it in a gun safe? I'm okay with that. But if you're inside your house, somebody breaks in the middle of the night, I think you should be able to have an operable gun. I have a question for you.
Shoot. I mean, so to speak.
Okay. You don't like originalism much. What do you like? How would you interpret the Constitution? Clearly, it has to have some meaning. How do you go about determining that?
So I should clarify, because this is, I nominate this for the hardball question if Alan's eligible to get it. But the originalism, and I should really emphasize this, everyone agrees is important. And I do like originalism a lot. It just disappoints me because it tends to come up short. So I think that Mr. Gura and I are actually not too far apart on one thing, is a jurisprudential matter, which is that there's a core, right? And sometimes originalism can tell you what the core of a right is because you have all these statements of the framers or the clear text of an amendment or something like that, and then you can get what the basic, the beating heart of an amendment is. And I think sometimes originalism gets us there. The problem is that the document, the Constitution, which is just the most brilliant legal achievement ever, is really short, right? It doesn't give us a whole lot to work with. You got to fill in a lot. And even when you add on the originalist gloss, you still have a lot of questions unanswered. And so I think the hard part is really saying, okay, well, you know, what does it actually mean to be originalist when you're looking at a problem that the framers never had to confront? And so I think, if anything, my problem with originalism is not with it as a concept, but just how we use it. And I think that it's best used to sort of give you a sort of baseline, identify the core of a right, if you can do that, and if there are some sort of clear historical practices that are clearly established, that have modern analogs, I say great. I just think that unfortunately most don't, and especially in an area like this where technologically things have changed so much, it's hard to draw analogs. Now, technological change does not mean that rights disappear, and the Supreme Court has decided this very clearly in Fourth Amendment, you know, area and stuff like that. It's just in order to sort of make that trajectory, in order to make that move from then to now, I think is tough to just say that, you know, originalism gives us all the answers.
Great, thank you. Okay, now if anyone has any questions, feel free to line up. Start over there.
Thank you very much for both of you coming. I'm Tyler Rosenbaum. I'd like to ask this question to Mr. Blocher, although I'd probably be interested in hearing either of you. But Mr. Gura mentioned that you'd probably agree that the Second Amendment would be incorporated. I just wanted to ask you to elaborate on that. Do you really think it would be incorporated? Would it join its cousins, the 7th, 3rd, part of the 8th, and not being incorporated? Especially in light of the adverse rulings in the 2nd and 7th circuits, and I think there was a ruling in the 9th circuit that distinguished it almost out of existence. I mean, what do you think about that?
But that's also a great question. Tyler clearly has some sort of legal experience here, so let me say a little bit more about what incorporation means. Right? And Alan touched on this during his presentation. There's a difference between constitutional provisions that limit the federal government and those that limit the states. And it has not always been true that the Bill of Rights, you know, for example, the First Amendment says Congress shall make no law, doesn't say anything about the states, right? Over time, the Supreme Court has sort of taken most of those provisions and made them applicable against the states. And that's what we're talking about when we say incorporation. As Tyler points out, there are some provisions of the Bill of Rights which have still not been incorporated. The grand jury requirement, the Third Amendment, you know, some things that just, for whatever reason, have not quite come up. But the approach that the Supreme Court takes now, and I happen to think it's a little fuzzy and a little weird as a matter of constitutional theory, is generally that these rights that are so fundamentally rooted in our constitutional and our sort of heritage apply against states just as much as they apply against the federal government. Now, as I started off, and I think Alan was very clear about this, if you take Heller as rightly decided, right, and it was decided, I can't complain about it anymore. I mean, it's there. If you buy the reasoning behind Heller, I think it's almost inevitable that the right that it announces is a fundamental one. I mean, if it's a self-defense right or if it's a right to prevent tyranny, it's just really tough for me to say that under this current approach that it's not fundamental. Now, politically, you know, as a policy matter, I don't like it. I think that ends the sort of what began in Heller, which is turning the Second Amendment completely on its head, that it was originally there to protect state militias from the federal government, and in the next few years it will now be used to limit state legislatures' power to protect their own citizens. But given Heller, I don't see the way around it.
Thank you. Let's go from this side.
My name's Matthew. I have a question for Professor Blocher. You made it seem like going forward we should treat gun laws with rational basis review. Why does that make like sexual orientation? But sexual orientation has never been a protected class under the Constitution, whereas textual rights are always afforded strict scrutiny. So why does that make sense?
So I have to start by disputing a premise, and also clarifying something that Alan said. It's actually not true that all enumerated rights get strict scrutiny. In fact, it's only parts of the First Amendment and parts of the 5th and the 14th, protected classes, which get strict scrutiny. Not even all free speech gets strict scrutiny. A lot of it gets intermediate scrutiny. In fact, there's a great law review article out right now calling intermediate scrutiny the test that ate everything, because it's now just like absorbing all of free speech doctrine, right? And then some parts of, you know, free speech are just completely cut out. They don't get no protection, right? So you can't quite say that everything in the Bill of Rights or everything in the Constitution gets strict scrutiny. I mean, you can go through the amendments. They all have different tests. The time, place, and manner test under the First Amendment, they all have different tests. You can't even say the Third Amendment has no doctrine, right? The Fourth Amendment has different tests. So it's not treating the Second Amendment as some sort of like second-class right. It's just recognizing that all these rights have different tests to govern them, and you have to figure out which one makes the most sense for the Second Amendment. So if it were true that everything in the Bill of Rights got strict scrutiny, then it would be hard to say the Second Amendment doesn't. Fortunately for me, that's not true even of the First Amendment. So.
Thank you.
Great. That side.
Hi, this is for Professor Blocher. Is that how you pronounce your name?
Blocher.
All right.
I'll answer either one.
My question is, If, at the time of the framing of the Constitution, the state militias were armed by individuals and their privately owned weapons, which were the most advanced weapons at the time, what leads you to think that the framers would not want individuals today to have more advanced weapons, say assault rifles, or things of that nature?
Well, I mean, this is a question. I mean, and this is why I say that the anti-tyranny view, which I said has some sort of constitutional theory behind it, actually catches some weight, right? If you really believe that the governing principle is the most powerful weapons at the time are what the Second Amendment, at any given time, or what the Second Amendment was written to protect, then that actually is sort of a natural conclusion of the theory, right? I happen to think that's not what the framers had in mind. I don't think that they thought that cannons, for example, were protected under the Second Amendment at the time of the framing, nor should they be now. Nor could I think they could actually imagine the destructive power of the kinds of weapons that we have today. I mean, it just simply wasn't on the radar for them, which is why I think that translating sort of original understanding into sort of current doctrine is what's tough. Now, assault weapons, for example, they're not regulated, just legally. As a matter of policy, we've decided not to regulate them, right? Not any more than any other kind of law. So politically, you can still sort of win a lot of these debates without even resorting to the Second Amendment. But that the sort of doomsday scenario is, I think, part and parcel of the anti-tyranny view of the amendment.
Thank you.
Thank you, sir.
Hi, my name is Adam Fries, and my question is to Mr. Gura. You stated in your arguments that you believe that the framers of the Constitution used the words militia and the people kind of synonymously. I was wondering why they didn't use the words for the people in the Second Amendment, why they used the word militia, and whether, if not to imply that at one point the militia would not be the same thing as the people.
Well, if they wanted to, they would have written it differently. For example, they would have written the amendment to say the right of the people to have arms while in service of the militia. The Fifth Amendment talks about you having a grand jury right in cases arising out of the militia when in actual service. So they knew how to use that kind of language. If they wanted to limit the right to militia activity, they did that in other parts of the Bill of Rights. But no, it was the right of the people. The militia was given as a reason, and of course, why that reason was foremost on their minds. I suppose it has to do with the fact that two things. First of all, the militia had just been used quite successfully to help repel the King of England. The militia did participate in the Revolutionary War. They were decisive in certain battles. In other battles, they were not as useful, but there was certainly a belief that the people's ability to be armed helped win the war. And also, remember, the Bill of Rights, all of it came as a reaction to demands made by the anti-federalists, who were afraid of the new government, the new central government becoming a new king, basically, imposing tyranny. And so you would see various state ratifying conventions make a demand for a Bill of Rights. And the right to arms, along with the right to religious worship, was the most commonly demanded one. Of all a Bill of Rights was demanded, it was proposed in 7 conventions, it passed in 5, and the right to arms was common to all 5 of them, in unmistakable individuals' terms oftentimes. So, it was the idea that this was a purpose that people had in mind. However, people were definitely familiar with guns, not just as a means of self-defense, but also as a basic means of providing food at the time. Hunting was a necessity for many people as well. So people were familiar with guns. This is just the way that they were most recently wishing to remember the right. But the core of the right was the English right to arms, which is based in self-defense.
Thank you.
All right, Professor Blocher, I'm wondering if it isn't a bit of a cheap shot in kind of contextualizing the amendment to suggest that at the time, of course, if we're looking at originalism, it applied only to white guys. Now, I think that Dick Heller, I think, probably was a white guy, but I don't think the import of this decision is to suggest that only white men may own firearms under it. And I'm wondering if you aren't failing to make the distinction between a living polity, between a polity as at large, versus the idea of living constitutionalism, the idea that we have to allow the Constitution to be unfixed rather than to recognize that the polity can grow while we live under a fixed Constitution.
Well, I'm not sure I understand the distinction. I mean, if what you're saying is that, if the suggestion here, if the argument is that the people protected by the Second Amendment has grown since the framers understood it, And I'm happy to call that living constitutionalism or living polity or whatever, but it's changing the way it was understood. Now, don't get me wrong. I don't think that women or minorities are uncovered by the Second Amendment. That is definitely not what Heller stood for. I mean, that is not the purpose of the decision, and I'm not trying to argue that it is. I just bring that up as a difficulty for turning to originalism, original practice, as a way to answer constitutional questions. I think you have to, and that's why I say, and why I said then, you have to know more about the purpose, right? You have to know what's going on at the time. And if the purpose was to, for example, as I think Alan would argue, to arm all the people who might have served in the general militia, and the definition of the people who may have served in the general militia has changed over time, then yeah, I think it's changed. But in order to do that, you got to know more about the purpose. And that's what I'm saying you can't just look to what practice was at the time.
Mr. Gura, would you like to?
Yeah, really brief response to that. Actually, the district did make a funny little argument that they buried in the brief. I think it was in a footnote somewhere, where they argued that Dick Heller was too old to be in the militia, and therefore didn't have a right. And this also came up in the district court arguments, where I was explaining to Judge Sullivan our theory of the militia and what it means, and I was explaining that I went to the DC code. Judge Sullivan asked if he was a member of the militia. And I said, actually, Your Honor, I'm sorry, but there's an exception for judges. You're excluded. And he didn't seem all that disappointed by that. But in any event, no, the fact is it's a right of the people, and they knew who the people were. The people were not the militia. The militia was formed from the people. But again, if the right is limited to the militia, then it's really quite a meaningless right, because the militia is defined by the government. The government tomorrow could say, we hereby define the militia to be all people who are left-handed between the ages of 17 and 17 and a half. Everybody else is not. They could do that. They can define the militia in the way they want, right? Well, that would sort of defeat the fact that you have an individual right against the Congress. I mean, that wouldn't make any sense to have a right whose contours can be defined by the government that's being limited by that right. That doesn't make any sense.
Thank you.
Hi, my name is Jerry. My question is for both speakers, and it has to do with sort of an interpretational tension that I detect in both your views. To Professor Blocher, I was wondering, if the court had accepted this rationale that you were talking about at the opening of your statement, that it had failed to provide the principles by means of which those outcomes could be derived, wouldn't that sort of be a problem for similar decisions elsewhere, regarding the First Amendment, the Fourth Amendment, and so on and so forth? And to Mr. Gura, my question is: so if you are insisting on the originalist principles to make these kinds of determinations, what do you do when, as you yourself acknowledged, you run up against situations like the Fallon situation, where it really isn't clear, what the principles are that are supposed to be deciding this? So, thank you.
I guess I'll answer first, since the question came to me first. I mean, the point is absolutely right, and Alan made this as well during his presentation, that there is not always a single case which defines the core of any given right, First or the Fourth or any other amendment in the Constitution, but elsewhere the court really has done, even if it's over time, a good job of defining what the core of the First Amendment means. For example, it's political speech, most people tend to think, right? Or the 14th Amendment prevents discrimination, right? And often that's, or equal protection clause, the 14th Amendment does. And the point is that sometimes the text is really clear, and it's not that hard, right? It's not that hard to figure out what equal protection is about, or the details are hard to work out, but the core is pretty easy to identify because the text gives it to you. But the Second Amendment, the court has decided, and I'm sure, and Alan clearly makes the good argument that it's perfectly clear, that this protects this individual right unconnected to militias. But for 200 years, the courts thought otherwise. The federal courts thought otherwise, right? At the very least, it was ambiguous. And I think that if we're going to try to go forward, the text doesn't help us. The courts really got to do a better job as far as giving us sort of what that core purpose value might be. Not an easy question to answer, and constitutional law struggles with this everywhere. That's why I say it's a short document. It doesn't give you all the answers.
Well, it's an interesting question, and maybe this is the hardball winner here, although I'm not the one who hands out the prize. But definitely, once you run out of a framing era practice that gives you guidance, or the core of the right as it is, construed against, the weight of history, you do run into sort of a gray area. What I've alluded to is the construction zone. And here the court does have, and it's not just a Second Amendment problem, it's also a Fourth Amendment problem, a First Amendment problem, any amendment problem. How do you balance the various interests of the government in regulating and of the people in maintaining their right? And there really is no hard and fast answer. We only have these sort of standards of review where the thumb is heavier on one side of the scale or the other. So I would say, for example, in the felon case, I'm a little bit troubled by the way that it's carried out, if only because we have so many silly felonies these days. You know, fishing without a license is a felony in some place, I'm sure. But the concept is a good one, right? If you've violated some really horrible law of society that shows you have no regard for the rights of other people and for the law, then maybe you should not have guns. And so the state has what we call, the magic words, a compelling interest in making sure that this person is disarmed. The felony was hopefully, well, if you're convicted of it, it was done voluntarily of your own volition. You've surrendered the right by committing the felony in the first place, and so it's not really unfair to deprive you of a right at some level, and so it doesn't really interfere with the traditional right of people, of law-abiding people, to have arms for self-defense or hunting or other things. Safe storage, again, interesting question. The state has some interest in making sure that guns aren't stolen, that somebody doesn't break into your house and take your guns, or that a child doesn't perhaps walk into the house and play with the gun that should not be playing with. At the same time, there is an interest that a person has in having a functional firearm for their defense. And how do we weigh that? I think we weigh that heavily on the side of the individual, but is there like a specific, concrete detail that's set out? Not in the Second Amendment any more than in the Fourth Amendment. What's a reasonable search? I don't know. I mean, that's completely wide open. But we've determined over the years reasonableness means one thing in a certain situation as opposed to another, what your background expectations of privacy might be. Those things are really where the judges earn their pay, we hope.
Thanks very much.
Hi, my name is Raphael Chaikin, and my question is for both panelists. And it may have been somewhat touched on in the previous answer. But if, in fact, militia was originally construed as meaning all able-bodied people, then my question is why, for 200 years, was the right not applied to individuals?
I disagree with the premise of the question. There was no concrete collective rights decision until I think the Supreme Court of Kansas in a 1904 case came up with it. I disagree with people who read Miller as announcing a collective right. There's been a lot of work done about courts that interpreted Miller most definitely have interpreted it as announcing a collective rights view, but that's not what Miller actually says, and we argued quite forcefully, and the Heller Court agreed with us that they never said such a thing in Miller. It's not what the decision stands for. And so I don't believe that we have that. In fact, quite the contrary. To the extent that the Second Amendment was argued at all in the history of our country, it was found to be an individual right. The first case that interprets the Second Amendment is a case out of the Supreme Court of Georgia in 1846 called State versus Nunn. The state of Georgia banned people from carrying handguns of a certain kind, and this is before the Civil War, obviously, before the 14th Amendment. Nonetheless, there was a strain of thought at that time that the Second Amendment did bind the states directly. Actually, John Rawl, who had signed the Second Amendment, was one of the ratifiers, was a member of the First Congress of Pennsylvania, wrote a treatise in the 1820s and stood for this proposition that the wording of the Second Amendment bound the states, and so the Supreme Court of Georgia found that actually using the Second Amendment, they would strike down this law. Later, towards the end of the 19th century, the Supreme Court, I believe of Idaho, a case called In re Brickey, also invoked the Second Amendment to strike down a ban on carrying guns. But you did not have many opinions using the Second Amendment because you did not have many federal gun laws. In fact, there were virtually zero federal gun laws until the 1930s. And of course, once Barron v. Baltimore, 1830s case, the Supreme Court got going, and some of the cases out of the Reconstruction era got going, it became very well understood that the Bill of Rights did not apply to the states directly. And so you had, on the one hand, not a whole lot of gun laws, so the question didn't come up, and certainly not gun laws at the federal level. It's interesting to note, though, that many parts of the Bill of Rights were not in use by the courts until the latter part of the 20th century. It was not until 1965 that the Supreme Court struck down an act of Congress using the First Amendment. So I'm glad that the court in the latter part of the 20th century discovered the Bill of Rights, started making better use of it, and of course, with more and more gun control coming up, it was only a matter of time before they addressed that question under the Second Amendment.
Thank you.
So if I can just add on to that, I mean, the reason I say that the Second Amendment was not an issue is because no federal court until Heller had ever struck down a law under the Second Amendment. There were still rights to own guns, and so state courts had a lot of experience with this issue. And two of them, like State v. None, again, is a case where the court mistakenly thought that the Second Amendment applied, when it didn't. Right, so they interpreted it, what it was essentially dicta, right? But state courts, as I said, and I just want to come back to this, have been applying the equivalent of the Second Amendment under their own constitution for years and years and years. And what happens in those cases? The vast majority of them, the gun laws, get upheld because they're applying this kind of reasonableness review. They're not applying strict scrutiny, they're applying the kind of review which I think makes the most sense in this area. So things like, it's not just felon laws, right? Because maybe the felon ban is a little overbroad. But what's underbroad is allowing misdemeanor. People who've been convicted of misdemeanors to have guns, because some of them are violent, right? People convicted of domestic abuse and stuff like that. Those cases come up to state courts and frequently get upheld under this sort of under the reasonableness review, and that's happened before this. But the Second Amendment was essentially off the table. Miller is an odd case because one side didn't show for the oral argument. It wasn't a particularly like joined case. It wasn't like as well argued as Heller, for example, by Allen, or as well briefed as Allen briefed Heller. But I mean, the same can be said of Marbury versus Madison, which you guys have probably heard of. Only one person showed up for that, and we still cite it. But in Miller, the question was really what kind of guns are protected, right? And the court said, and Allen and I will definitely disagree about this. The justice disagreed about this. Do you have the exact language in front of you?
Yeah, I do. But go ahead, I'll find it.
So that these two guys have been convicted for been charged under this National Firearms Act for possessing sawed-off shotguns, right? And they challenged their indictment. The court said, in a very, we'll definitely agree, opaque opinion, that these laws that the court could not take notice that these guns had any reasonable relationship to a well-regulated militia. Is that it?
Yeah, but
something along those lines. And Allen and I definitely have an argument about why that doesn't mean that the Second Amendment has something to do with the militia. But the argument on the other side is, why would you even ask that? Why would you care unless the Second Amendment actually has something to do with militias?
Thank you.
I have the exact language.
Yeah, so if we can just get the
really
language.
Basically, the facts in Miller was a gangster. He had a sawed-off shotgun without the required $200 tax stamp on it. His lawyer sent a telegram to the clerk of the Supreme Court saying, I can't afford the train ride to Washington from Arkansas. What do you think I should do? The telegram sent back from the court was submit on the government's briefs. The lawyer said, I'll do that. And so it was a one-sided case. Nobody showed up, so I'm glad I was able to do a better job than that. Because I live a lot closer. I only have to take the train in from Alexandria. In any event, the court in Miller didn't actually decide that the gun at issue, the soft shotgun, was outside the Second Amendment protection. The court said, we don't have enough evidence. We're not going to take judicial notice. Here's what they said about the kind of guns that are protected by the Second Amendment. Individuals called for militia duty were, quote, expected to appear bearing arms supplied by themselves and of the kind in common use at the time. People who are expected to show up for militia duty. And then, of course, they said, we don't know if this is a militia-suitable weapon, meaning, I think, using that language, is this the kind of arm that a person would supply himself of the kind in common use at the time? It was sent back for trial. Unfortunately, Mr. Miller got murdered before that trial could take place, so maybe he needed that sawed-off shotgun after all. We'll never find out. But what's interesting about Miller is the government did argue. There was a collective rights theory in the government's brief, and the court blew right by that. It would have been a very simple case to say, Mr. Miller, you're not a member of the militia, you're a bank robber, you're not claiming that you're a militia duty, you're not claiming that you need this gun for the state militia, therefore you have no standing to make this argument to go away. That's not what they said. They sent it back down for a trial about the nature of the gun. Presumably, had Mr. Miller survived and presented some evidence, perhaps he would have been acquitted on Second Amendment grounds. We don't know because he died.
Thank you. As we just have a little bit of time left, I'd like to ask the speakers to keep their answers really as short
Sure.
as possible.
This is like Supreme Court all over again.
Okay. Hunting was just briefly mentioned, but given that the rights granted to us by the Bill of Rights have regulations that don't constitute as violations, what are each of your opinions on the use of guns for so-called sport, taking into account that the accidents that occur as a consequence?
I think hunting is a traditional lawful use of firearms. It's been with us since the beginning of time and since the beginning of firearms, definitely in this country. So the government can impose regulations in the interest of hunter safety, and virtually all states do that. The federal government probably does that as well. I don't know, but I don't have a problem with the idea of regulating for safety as long as it actually serves a compelling state interest and doesn't restrict people's ability to have it for traditional use.
And I like regulations as long as they're not unreasonable. I mean, I think we agree, at least on the sort of result here. It's undoubted that hunting was a big use of guns at the time of the founding. I don't think there's a lot of evidence to show that it was what the framers had in mind when they wrote the Second Amendment. They weren't worried about, the English taking away their right to hunt or the federal government taking away their right to hunt. I don't think it was the purpose behind the Second Amendment. Now, it could be an additional sort of benefit to having rights for your militia or for your self-defense or whatever. I mean, the First Amendment protects things beyond political speech, but I don't think it was what the framers had in mind.
Yeah, one interesting note is that historically the King of England had used the game laws to disarm his political opponents. And so you did see in some of the people demanding a right to arms specifications. For example, in Pennsylvania, the Pennsylvania minority that demanded a right to arms spoke about the right to arms for Dumpty Dum purposes, including the right to use arms for hunting.
But that was the minority view that was rejected.
Yes.
Right? So this is a proposal that was made and voted down.
But it was, but that sentiment was common in the United States, and 5 of the 7 proposals were accepted. And there's no dispute that the game laws of England were used by the monarchy to disarm political opponents, and they were seen as an excuse to disarm people, and this was an evil that people sought to remedy.
Great.
Yeah, my question is primarily for Mr. Gura, since you're working directly in the litigation. I know you didn't really sort of rejected the comparison with Roe, but in one way that Heller is similar to Roe is that it sort of took a debate in the legislative sphere and sort of moved it into the judicial sphere. I was just wondering where the litigation, where the debate is going to go from here. Is it going to be a lot like Roe, where there's been a lot of grappling in the courts on specific things and not so much in the legislation anymore? Or are we going to see more legislative action continue?
Well, while I'm not an expert in the area of abortion, I do think that states still do grapple with a great deal of abortion restrictions. There's new ones being dreamed up all the time. The whole debate about partial birth abortion, for example, is one that I think is a recent historical memory. I don't remember hearing about this issue more than 10 years ago. Clearly there are fewer ways to regulate abortion than there are ways to regulate guns. I think the universe of possible regulation is bigger when it comes to guns, and so you may see more legislative activity, more litigation activity. But I don't have a problem with the idea that if you have a certain right, then yeah, the government has some room for regulation, but it needs to look over its shoulder because it's going to get sued.
I think the best answer to one interesting answer to your question, if you like following up on this, is Justice Scalia in Planned Parenthood versus Casey talking about Roe. Of course, Justice Scalia also writes Heller, and he says, Roe, this is a quote, Roe destroyed the compromises of the past, rendered compromise impossible for the future, and required the entire issue to be resolved uniformly at the national level. By foreclosing all democratic outlet for the deep passions this issue arouses, by banishing the issue from the political forum that gives all participants, even the losers, the satisfaction of a fair hearing and an honest fight, by continuing the imposition of a rigid national rule instead of allowing for regional differences, the court merely prolongs and intensifies the anguish. Politically, I don't think that this leads to a lot of room for compromise. Now, if there's a right, doesn't matter. You got to enforce a right, whatever it does to political debate. But as far as whether or not it'll intensify the gun control debate, I imagine it would.
Thank you. 3 more quick questions and answers.
Hi, my name is Dan Davidson. This question is for Mr. Gura. I was wondering if you think the Second Amendment guarantees the right to carry a firearm at a place like a public university or a public school, where there's been, some people feel uncomfortable about this, but it's very conceivable that I'd want to invoke my right to self-defense in that situation. So I was wondering if you think that the Second Amendment extends to that.
Well, yes, it depends on the context. There are going to be some activities in some buildings in some situations where a firearm is not appropriate, and others where it would be. Just like you could say that about life in general. You do have some students who are responsible, law-abiding. Many of them are, in ROTC, have some firearms training. I think if a guy comes back from a couple of years in Iraq, and he's going to college on the GI Bill or something, that to take away his right to self-defense is not fair and doesn't serve any sort of public purpose. Of course, the tragedy at Virginia Tech was horrible, but that just proves what we always know, which is that people who are intending to commit some sort of a crime aren't really going to care much that it's against the law. I don't know that could have turned out any worse if there had been somebody there on the scene who was licensed by the state of Virginia, as many people are, to carry a firearm and can responsibly use it in self-defense. There was a recent incident in Georgia, I believe, a college near Atlanta, where there was a home invasion in an apartment full of students during one of their parties. And it was pretty clear that the 2 gentlemen were going to kill everybody. and somebody had a handgun in their backpack and they were able to defend themselves. This was in the news just a few months ago. So yeah, I mean, you can have good outcomes with handguns just like you can have bad outcomes.
Thank you.
I'm just curious if the sort of core argument of Heller and the Second Amendment is self-defense, like the right to have a basic weapon against an attacker or whatever, then what is the argument against other gun regulations? Because presumably, like, one bullet from a handgun is going to have the same effect as 15 from an AK-47 against an intruder in your house.
Sorry, the question is why is...
What's the principle, I guess, against other types of gun regulation besides handguns?
Like, why would an AK-47 not...
Why do people, like, not want AK-47s regulated and other sorts of guns regulated?
Well, I mean, interestingly, I think if you think that... I think I'm following the question here, but ask again if I miss it. If the purpose of the Second Amendment is just to protect self-defense right to arms, and that's the core of the right, then it seems to me that the only kind of gun that's going to get core protection is handguns. Because those are the, I mean, as they argued very effectively at the Supreme Court, though that is the preferred weapon, as the court recognized, that is the preferred weapon for home and self-defense, and it's rare that somebody needs an AK-47 to defend themselves against an intruder. So I think it actually might limit the universe of guns that would be protected to handguns and not AK-47s. Is that responding to your question? Okay.
Yeah, I disagree with that answer. I think Heller gave you the common use test. That is, if there's a gun that would be of the kind in common use by law-abiding people for lawful purposes, self-defense is the primary lawful purpose, but it's not the only one, then that gun cannot be banned. And I suppose if there was a case challenging the constitutionality of an AK-47 ban, you'd have to look at the AK-47, you'd have to see how popular is this gun in America today, what do people use it for, how prevalent is it, and that would give you your answer.
The hard part with the common use test, of course, is how do you determine if an AK-47 is in common use? Is whether or not it's legal, right? And how do you know if it's legal? Is whether it's been legislated against.
No, that's the circularity argument is what I hear a lot from some people, and I think circularity is an issue in many areas of constitutional law. How about the Fourth Amendment? The touchstone of the Fourth Amendment is whether you have a reasonable expectation of privacy. What if you live in an Orwellian surveillance state where John Ashcroft is listening to all your phone calls, and you know, and the TV's, you know, at some point, I mean, we saw this in the 1920s. The Supreme Court considered and rejected the idea that wiretapping was something that attached a Fourth Amendment privacy interest. And of course, in the late 1960s, cats, they reversed themselves, and they decided, gee, as a matter of fact, you do have an expectation that your phone calls would be private to yourself. The government needs to go get a warrant to get a wiretap now. And the court looks to traditional background expectations. Same thing with the handgun ban in DC. This ban was 30-something years old at the time. Handguns were not in common use by law-abiding people for traditionally lawful purposes in Washington, D.C., but the court could say, look, generally the Americans prefer this kind of gun, so even though, of course, the court didn't need to say this, handguns are not common today in D.C., we think that they should be if that's what people want. And so it's a conditional test. It's would be, not necessarily is, and I think that ends the circularity problem.
Thank you. Last question.
It's true that the framers of the Constitution weren't infallible. So do both of you believe that the country is better off with the Second Amendment as it applies to individuals, or would our country be better off if it were illegal to possess things like handguns?
Oh, man.
Well, I think we're better off with the Second Amendment. I think that the scientific data shows that conclusively. I think it's the correct result. I think it's the morally just result. I don't think that we should be telling people that they may not defend themselves or have the means to defend themselves. And again, people disagree. I mean, again, guns are a leading cause of statistics, and people will argue about this all day long. I'm quite comfortable in arguing that I'm not just right as a matter of law, that I have this clever legal argument, but it's leading to mayhem on the street. No, I actually think I'm doing some public good with this, that people would disagree.
And I think that this is another thing that we agree about, which is that the statistics don't help a whole lot here. I mean, there are tons of people spend their careers arguing either side about whether more guns, less crime, more guns, more crime. I mean, the statistics really aren't going to lead you, I think, to an easy conclusion about whether more guns are a good idea or a bad idea. I happen to think it's nice to have, to give legislatures the sort of police power to regulate. If there were no Heller, right, that I think that we would probably be better off in that. But just to kind of wrap up on what we've been talking about the whole time, this politics and principle, it's an interesting twist on this case that many of the people, who are on Allen's side arguing for these broad gun rights are not themselves gun owners. I mean, they're not people who want to go home and shoot their guns at all times. And a lot of the people on our side grew up with guns and liked shooting them, right? But didn't think there was a constitutional right to do it. I mean, there's a lot of things I like to do, but I don't have a constitutional right to do it. And I think, hopefully, at least, yeah, I might. If the Ninth Amendment works, at least I might have rights to. But the point being that, like, in a very inspiring, I hope, way, this debate has been, and hopefully will continue to be, about principle and not just about our sort of personal preferences for guns or gun control.
Great, thank you. I'd like to invite you all to the small reception outside. Thank you for coming. Let's have one more hand for our speakers.